Many times in a DUI case, the defense lawyer and the prosecutor will reach a plea bargain to reduce the DUI charge to something that we call a wet reckless, which basically just means a reckless driving involving alcohol. Now, there's pros and cons to a wet reckless, and I want to talk about those pros and cons today. But first of all, just by way of clarification, if you take a wet reckless deal, it doesn't necessarily mean that you were driving recklessly. So people say all the time, well, but I wasn't driving recklessly. I was stopped at a checkpoint. I mean, the cops didn't even see me driving at all. Well, it's what we call a legal fiction. And what it means is even though you weren't driving recklessly necessarily, you still agreed to plead to that charge because it's better than pleading to a DUI. Now, the benefits of a wet reckless are several-fold. First of all, there's usually a shorter time of probation. There may be no DUI school, and if there is, it's usually a much shorter DUI school. The fine is usually less, and it does not trigger a court-imposed license suspension. Now, if you lose your DMV hearing, you might get a suspension anyway that way, but simply being convicted in court of wet reckless does not automatically trigger a license suspension. And a lot of people feel that it doesn't look as bad on their record as a DUI or driving under the influence does. So there are some definite benefits. Now, in a situation where someone is looking at a second-time DUI or a third-time DUI, the benefits of a wet reckless are even greater. Because with each successive DUI that you get, the penalties are exponentially greater. So on a second-time DUI, for example, there's a minimum of 4 days jail and usually an 18-month DUI school. On a third-time DUI, it's a minimum of 120 days jail and usually at least an 18-month DUI school and a 3-year license suspension. But none of those mandatory penalties apply with a wet reckless. So if we have a third-time DUI client and we can get his charge reduced to a wet reckless and avoid a 3-year license suspension and avoid a minimum of 4 months in jail, that can be a great benefit to the client. Now, the downside to a wet reckless is that it's still priorable as a DUI. And what that means is that if you're convicted of DUI or wet reckless and you get another DUI sometime in the next 10 years, God forbid, then it would be treated as a second offense, second-time DUI, even though your first case was reduced from a DUI to a wet reckless. The court will look at it as a functional equivalent of a DUI on your record. And that's very serious because you never know what's going to happen in 10 years. And I have clients who come to me and they say, look, this has been a wake-up call for me. I've learned my lesson. I'm never going to take a sip of alcohol and get behind the wheel again. And I hope that's true. And I mean, I think that would be a great thing if they lived up to that. But the reality is they may be at a party, they may be at a wedding, they may be at an event someday, and they unfortunately get in this situation again. It's much better if you don't have that DUI prior on your record, whether it's a DUI or wet reckless. So that's the downside to wet reckless, is it's still priorable as a DUI. But in many cases, in a second-time, third-time DUI, and even in a first-time DUI, it definitely can have benefits. There's definitely value to getting your DUI charge reduced down to a wet reckless.